So I'm just going to do a little bit of framing first and introduce myself, and then we'll hand it off to our wonderful complement of presenters. My name is Ann Stone. I'm one of the founders of the Washington Fatherhood Council, and I'm now retired, but continuing to support this wonderful work that needs to happen to support fathers to be the dads that they aspire to be and create greater inclusion for fathers in families and family policy. And this is a tricky one, right? This is a difficult topic um, for us to understand, but also um, for us to navigate. Can you go to the next slide, please? So the council came together around this provider learning series to make sure that all of the training and the awareness raising activities that we did were grounded in the science. And so this is really the science boiled down into kind of three buckets of what we know about the role of fathers. And clearly the first one is a powerful statement and has a plethora of data behind it that says that and families do better when fathers are positively engaged in their lives, and that is regardless of their living situation. So whether they're cohabitating or not cohabitating, what the formation of the family is, and that is prenatally all the way through young adulthood and into their parenting themselves. So a child raised in a home, in a family where father has been positively involved is much more likely to be a strong parent themselves and to feel that their role in fathering is valued. And the reason that that is that we all parent differently. And so fathers do play a unique role in their child's development and their family's well-being. And remember that when the Washington Fatherhood Council says fathers, they really intend that to be a very big tent. So don't get too hung up on, the narrow definition of a nuclear family, but really about father-like parenting, and understand that as we play those different roles in mom-like parenting and father-like parenting, that we have a profound impact on child's development. And across the developmental domains, but really importantly, social emotional development. Kids learn a lot from fathers around affect regulation and staying in bounds within the guardrails of the rules, goal setting, following goals. I mean, we've learned a lot over the last couple decades about the positive role, and that doesn't mean that it's moms or dads. It means that kids need both. And there's a wonderful Children's Bill of Rights that was created by Dr. Jeffrey Johnson and his wife at the national level that says the first statement in it is that every child deserves the right to be cherished by both parents. And then, of course, it's followed by, and both parents need to play their role. So it's about rights and responsibilities, but it's absolutely true. And that is why we've paid so much attention to this topic in our state for the last 10 years. And the last one is that fathers should have the support and resources that they need to be supported in the way that they can aspire to the kind of parenting that they know that they can be and that they want to be. And that is really also grounded in the dearth of resources for dads. So this statement came out of a lot of work that the council did to determine that there is some really huge equity issues around resource and access, and how policies and systems are hardwired, often with biases that make it more difficult for dads to get the support and the resources that they need. So next slide, please. So we just want to remind you of that as you're listening to this. That's why the work is happening. That's why the work is important to all of us, regardless of where you sit at this table. So if you could please take a moment and introduce yourself in chat, along with just a brief one-liner about where you sit in this conversation of fatherhood, how you come to this table and why you come to this table, that would be fantastic. We have an amazing group of presenters for us today that have done this conversation with us several times. Sarah Jackson is here with the King County Prosecutor's Office, and Jill Schropp and Bridget Pierce are here from the Division of Child Support within the Department of Social and Health Services. And the last piece I want to do before we launch here is just a huge thank you to the Department of Children, Youth, and Families for picking up the administration of the council when the budget cuts eliminated the staff positions that were dedicated out of the DSHS budget. So thank you so much. And I'm going to turn it over to Bridget, I believe is going first. And just to remind you that you are being recorded so that we can capture this information and put it out on the website for folks who have not seen it, or if you saw it and you were excited about what you saw and you wanted to share it with other people, it will be posted on the website in a format that you can take it and pass it on. So Bridget, thank you. And folks will probably give you a bit more of their background as they introduce themselves, but I'm going to have Marilyn, if you could advance us to the next slide. That
we're actually going to.
Actually, we can stay there.
Yep, we can stay here.
You want to stay on this one? Okay.
Yep.
There we go.
Go ahead, Sarah.
Hi, everybody. Thank you so much for coming and joining us today. We're excited to be back. So we're going to do some brief introductions, and then we will jump right into the slideshow. My name is Sarah Jackson. I am with the King County Prosecutor's Office. I have been with the office for 20 years now, and I have worked in all of our divisions in criminal, civil, and now in family support. And in family support, I have worked in all of our areas as well, in modifications, parentage, and our contempt of court unit. And we're excited to be a part of this. We appreciate the invitation to present. And I hope everyone can walk away with some useful information today. So I will now turn it over to my partners with the Division of Child Support.
So my name is Jill Schropp. I am the Parentage and Paternity Initiatives Manager. I have worked for the Department of Social and Health Services, Division of Child Support for over 25 years. And I have been in my current role as the Parentage and Paternity Initiatives Manager since 2021, which now seems like a long time ago. The Parentage and Paternity Program works with birth providers and other partners to help provide unmarried parents an opportunity to voluntarily sign the acknowledgement of parentage. And our program also manages the voluntary paternity testing program. And I am lucky enough to work with Bridget Pierce.
Yes, and Bridget Pierce here. I am the assistant manager of the Parentage and Paternity Program, working with Jill. I've been with Department of Social and Health Services, Division of Child Support since 2008, so 17 going on 18 years. And I have been working specifically in parentage and paternity in our local field office beginning in 2012. And then I moved over to this position with Jill in 2021. So we are excited to be here today. So parentage and paternity. In 2018, the Washington State Legislature passed Senate Bill 6037. This replaced the prior Uniform Parentage Act. The UPA was codified into law as the Revised Code of Washington, which went into effect in January 1st, 2019. The current Uniform Parentage Act recognizes the diversity of families, non-biological parent-child relationships, and outlines surrogacy agreements in Washington. This legislation changed some of the language we use to more accurately describe families, addressing the establishment of a legal parent-child relationship, or parentage. Parentage is broader than paternity, which is the legal father-child relationship. There are many benefits to children and families that come with legal parentage establishment. I'm not going to read everything that's on the slide, but some of the key things here: children know who their parents are. They have emotional relationships with their parents, access to medical and life insurance, access to family medical history. Legal parents have legal rights that a biological or other parent may not have until that legal relationship is established. And various kinds of support, including financial support and access to other types of benefits. So there are lots of benefits that come from that establishment of a legal relationship that doesn't exist when that legal relationship has not been officially established. There are only 3 ways to legally establish parentage: marriage, court order, or acknowledgement. 1, the child can be born during a marriage or born within 300 days after the termination of a marriage. 2, parentage can be established by a court order. I think we're going ahead a little bit, guys, here. We can go back a couple slides. There we go. We're going to stick on this one for a second. Parentage can be established by a court order. However, as many of us know, the court process can be difficult and expensive. It often takes a long time. So there's a third option, which is parentage can be acknowledged. The acknowledgement of parentage is a faster and less expensive option for establishing parentage administratively outside the court system. The acknowledgement form is maintained by and filed with the Department of Health. We will cover each of these processes in more detail during this presentation. Jill and I are going to discuss the marital presumption and acknowledgement processes, which is primarily what we focus on, and then Sarah will address the court order process. If parents are not married and the father or second parent doesn't sign an acknowledgement of parentage in the hospital, the birth certificate will list the father or second parent as none named. If the Division of Child Support gets a case with no father or second parent named on the birth record, DCS does pursue parentage establishment. So if a birth parent is married at the time a child is born, their spouse is presumed to be a legal parent of the child. Additionally, an ex-spouse is legally presumed to be a parent if the child is born within 300 days after the termination of the marriage and parentage was not otherwise addressed in court as part of the dissolution or divorce. If a spouse is pregnant while a dissolution or divorce is happening, the legal parental relationship between the spouse and the unborn child can be addressed in the divorce decree. If parents are married after the child is born, a marital presumption may be created after the fact in 3 ways. The spouse may file an assertion of parentage with the state registrar of vital statistics that asserts they are a presumed parent. Or the spouse agreed to and is named as a parent on the child's birth record. Or the spouse resided in the same household with the child for the first 4 years of the child's life, and they have openly held out the child as their own. So I think this is where I turn it over to Jill.
So the acknowledgement of parentage. There's been a very long and successful parentage and paternity program in the state of Washington. 30 years ago, the courts were jammed with paternity actions as the out-of-wedlock birth rate went up. All states are required by federal regulation to have a process for voluntary acknowledgement of parentage. And this option creates an alternative avenue for families to voluntarily establish parentage that is less expensive and more accessible than going through the court system. Diverting these processes from the courts also takes many actions off the court docket, freeing them up for others who need access to the family court system. In 1989, so quite a long time ago, when the partnership between the Division of Child Support and the Department of Health was formed, there had been about 2,000 paternity affidavits filed per year. In the first year of the partnership, that was 1990, the number more than doubled to about 4,500 filed, and it has grown steadily since. Over 23,000 acknowledgements of parentage were filed in 2025, saving many families the time and expense of going to court. In 2025, parentage was established using the voluntary acknowledgement process for over 90% of children born to unmarried parents in Washington state. Over 80% of those acknowledgements were signed at the hospital at the time of the child's birth, meaning the process was free to the families who did not need to pay a filing fee. If the families who established using the acknowledgement of parentage process came to the Division of Child Support for help establishing parentage in court instead, it would cost Washington taxpayers millions of dollars each year in court costs. So the acknowledgement of parentage is a legal form that may be downloaded from the Department of Health website. and is used to establish a parent-child relationship and add a second parent to the birth certificate. So it's very accessible form. We're still on that same slide. The acknowledgement of parentage form can only be used if everyone agrees and no other person claims to be a parent of the child. The AOP form can be signed by a birth parent and either an alleged genetic parent, a presumed parent, or a parent through assisted reproduction. The form actually has 4 pages. The first page is the form that gets completed by parents. The second page lists statements of acknowledgement that explain to parents that by signing the form, they become a legal parent and they should only sign the form if they are sure they are a parent of the child. It also gives the parents their rights regarding rescission and challenge of the AOP that we're going to talk about in a second. The instructions for completing the acknowledgement of parentage and definitions are on pages 3 and 4 of the form. And the form, again, I mentioned, is very accessible. Any parentage form can be notarized or witnessed. The parents choose which option they prefer. It is possible that on the same form, one parent could choose to have their signature notarized, while the other parent may choose to have their signature witnessed. A witness just witnesses the signature of the person signing the parentage form. They have to be over the age of 18 and not related by blood, marriage, or adoption to the individuals who sign the parentage form, but it could be a friend, a neighbor, someone who knows who they are. A notary confirms the identity of the person signing in front of them and completes the notary portions of the acknowledgement of parentage, including their stamp and expiration date of their appointment. Those completed forms, again, must be filed with the Department of Health in order to be valid. There is no filing fee for the family if the acknowledgement of parentage is completed at the hospital within 5 days of the birth and submitted for filing through the hospital. Otherwise, there is an $18 filing fee. And the Division of Child Support will pay the fee for the family if the form is submitted through the Division of Child Support. DCS does not need to have an open case for the child, so completed forms can actually be dropped off at any Division of Child Support office, or parents can come to the Division of Child Support to obtain and complete the acknowledgement of parentage form. Division of Child Support staff will provide written and oral information about the form, answer questions if the form is being completed in the office, and are also available to notarize or witness signatures at no cost. The Division of Child Support does have policies that require ID to be provided when an acknowledgement of parentage is witnessed or notarized, but any family can come to the Division of Child Support for these services. And again, no child support case is necessary.
Jill, before you jump off this one, there's just a clarifying question in the chat about the notary process. Oh, Bridget already grabbed it. You guys are so on it. I'm so impressed.
This is why Bridget went first, because she's great at answering questions in the chat. The acknowledgement of parentage does not address custody, visitation, etc. It only addresses that legal establishment of parentage. Next slide. So what if someone wants to deny they are the parent? They may complete a separate form that's called the denial of parentage form. The denial of parentage is a legal form that allows the person denying parentage to be discharged from the rights and duties as a parent. So by filing this form with the Department of Health Center for Health Statistics and paying an $18 filing fee if it's sent alone, that person denying parentage will not be listed on the birth certificate. A denial of parentage is only valid when an acknowledgement of parentage has also been filed. So the forms can be filed together for the Department of Health fee of $18, or when filed separately, they each have an $18 filing fee. If the birth parent is currently married or was married at any time during her pregnancy, and the spouse or ex-spouse will not be the parent listed on the child's birth certificate, the spouse or ex-spouse must sign and file the denial of parentage. The denial of parentage can also be signed by a person who might be genetically related to the child but will not be a parent listed on the child's birth certificate. The parents who complete the acknowledgement of parentage should indicate if someone will be denying parentage by marking the box at the top of the acknowledgement of parentage. And if the denial is submitted separately from the acknowledgement, that's that second $18 filing fee. There are, if someone has completed either the denial of parentage or acknowledgement of parentage, and they want to reverse the change to the birth certificate that either of those forms made, there are two options or processes to reverse those changes. The first is the rescission of parentage form, and again, a separate Department of Health form. An individual who signed an acknowledgement of parentage or denial of parentage may change their mind and rescind the parentage form. The rescission of parentage form must be completed and filed with the Department of Health Center for Health Statistics on or before 60 days after the acknowledgement of parentage or denial of parentage is filed with the Department of Health, or before the first court proceeding if folks are going to court. The rescission of parentage is voluntary and does not require a court proceeding. An $18 filing fee is required to file the rescission of parentage with the Department of Health. Once the rescission of parentage is filed, the child's birth record will change back to the prior record information before the acknowledgement or denial of parentage form was filed. So whatever form was being rescinded. After that 60-day rescission period, the acknowledgement of parentage or denial of parentage may be challenged in court. A challenge to the acknowledgement of parentage or denial of parentage is permitted for limited reasons, including fraud, duress, or factual mistake, and must be made through the courts within 4 years of filing of the form with the Department of Health Center for Health Statistics. Next slide.
Okay, before you move on, Bridget, do you want to grab this one about a deceased parent in the chat?
She's so fast.
So fast. Okay, I'm just going to stop asking these questions then. I do wonder though if some of these might be of interest to the broader group. So,
Shall we
we might
go
want to
back?
pull
Roberta,
some. Can you go back
we'll
one?
go back. Roberta asked, have one notarized and one signed without notary works. So when there are two parents, their signatures must be either notarized or witnessed. One parent could choose to have their signature notarized. So say it's the birth parent chooses to have their signature notarized, but the second parent or father may choose to have their signature witnessed because it's more accessible to them to have their signature witnessed. They can't get to a notary. Either option works.
Go ahead.
Either option works. The next question, if a parent was not on the birth certificate and now is deceased, can a genetic grandparent acknowledge? So the acknowledgement of parentage must be completed by the parents. So a grandparent usually would not meet the requirement as a parent, and a court order or going to court to establish that genetic grandparent as a grandparent or a parent would be the appropriate venue.
Thanks.
And then there's another question. What if a mother refuses to take the DNA test if court ordered? And I think we'll get into that later when Sarah talks about the court order process.
Yeah.
So if we can just put that one on hold. Okay. So our Division of Child Support Parentage and Paternity Program, we maintain strong relationships with the state's birthing hospitals. We provide outreach and support to hospitals and midwives across the state. And the state's Parentage and Paternity Program is required by law, that federal regulation that requires states to establish a program for voluntary paternity establishment in cooperation with hospitals, state birth record agencies, and other entities designated by the state and participating in the state's voluntary paternity establishment program. So our hospital-based portion of the program is operational in all private and public birthing hospitals statewide. And we also work with midwives and birth centers. It is a federal requirement. Oops, we're still there, sorry. It's a federal requirement for birth providers to provide both oral and written information about when they are offering the AOP. There are several ways for birth providers to provide oral information because we want to make sure that everybody has the information that they need before they're signing this legal document. Birth providers can show or share an acknowledgement of parentage video that's available on the DSHS YouTube channel or on a DVD. They can call a telephone number to hear the information and listen to a message about the acknowledgement of parentage, or hospital staff can speak with parents. The written information may be provided in the acknowledgement of parentage statements of acknowledgement, or the established parentage for your child's sake brochure that is a Division of Child Support brochure. Division of Child Support staff are also available to clarify information and questions if people have them about parentage establishment. We do reimburse providers. Hospitals and midwives are eligible for reimbursement of $20 acknowledgement of parentage when the form is completed at the hospital and successfully filed at the Department of Health by the Division of Child Support. We're the ones doing the reimbursement. All but a handful of the state's birthing hospitals do request reimbursement through an electronic process, and that's for their time spent offering that acknowledgement and providing those resources to families. We want everybody to be aware that there are several time frames that parents and providers have. Parents must return the acknowledgement of parentage to the hospital within 5 days of birth. Hospitals must submit that acknowledgement of parentage within 10 days to the Department of Health Center for Health Statistics, and parents may submit, but outside of those timeframes, parents may submit the completed acknowledgement of parentage to the Department of Health Center for Health Statistics with the $18 filing fee at any time in the child's life, so even when the child is an adult. Parents may submit the completed acknowledgement to the Division of Child Support at any time during the child's life as well, and the Division of Child Support will pay the filing fee to the Department of Health Center for Health Statistics. And I'll just note, Bridget added to the chat the Department of Health website regarding the acknowledgement of parentage if people have more questions. The Division of Child Support offers free voluntary genetic testing to unmarried parents who are interested in establishing paternity to help parents settle the question of the child's biological father early in the child's life and avoid any doubt about paternity. The main part of the voluntary paternity testing program is the free genetic testing. The voluntary paternity testing program brochure is offered to an unmarried mother and a possible father who do not sign an acknowledgement of parentage at the hospital. It's a great program for parents who are not sure of paternity. The parents do not need to have an open child support case in order to participate in this program. The application is relatively simple, with sections for the possible father's information, the mother's information, and the child's information. Both the mother and possible father need to sign the application since the process is voluntary. The parents complete the postage paid authorization form and send it into the Division of Child Support. There are strict qualifications for our program. All of the following must be true. The child has to have been born here in the state of Washington. The child must be less than 2 years old. The birthing parent cannot have been married at the time of the child's birth, and no other circumstances creating a presumption of parentage can apply. The second parent is not, or no second parent is named on the birth certificate. Parentage hasn't already been acknowledged or established legally for the child by a court. And the birthing parent and alleged father have been offered an opportunity to complete the acknowledgement of parentage, but declined. And both the birthing parent and alleged father are currently over the age of 8, or currently at least 18 years old. We can't test minor parents. Both the birthing parent and alleged father are considering whether to sign the acknowledgement of parentage voluntarily, and they agree to participate in the program. Key, it's voluntary. We unfortunately are not able to assist when the mother or alleged father are incarcerated because the parties need to be able to go to the lab, and we can't test if the child has not been born. The child has to also be available to go to the lab, and if the child is not well and still in the hospital, we have to wait until the child's been released for the hospital. Once we receive that application, we contact the person who's been marked on the form and make sure that they meet all the criteria that I just listed and they can participate in our program. We ask them to confirm all the information that they provided, because sometimes people move. We want to make sure that we know where they're at and that they can get their results. We schedule through our contracted provider, LabCorp. So we're not actually doing scheduling. LabCorp is doing the scheduling, and then we notify the parties of the appointment. They go to the lab that is at a location nearest where they live, and they get tested, which it's just a buccal swab, a cheek swab, so it's not invasive. Their samples are collected at the local lab and sent to the main LabCorp lab in North Carolina, where they do the science of paternity testing, and it takes about 2 to 3 weeks from the date that they have their appointment and have their samples collected until they get their results in the mail. And through our program, about 25% of the possible fathers that we test are excluded, meaning that they are not the biological father. If the alleged father is included, that they are the biological father, we hope that they'll complete the acknowledgement of parentage. And the total process takes about 5 to 6 weeks, which is a big difference from the court process, which can take 5 to 6 months, a year, sometimes more, depending on how things go. If we do find that the person that we tested is not the biological parent, we can test other possible fathers through our program. And our voluntary paternity testing program was added as part of the parentage and paternity program to help increase the percentage of children with this parentage established and provide parents the opportunity to make sure they know for sure who the father is, eliminating the questions that sometimes lead to rescission or challenge of the acknowledgement of parentage. And when parties do not meet the qualifications for our program, which happens, we do try to offer other available options depending on circumstances. So if there's no presumed, acknowledged, or court-ordered second parent on the child's birth certificate, either the mother or possible father may apply for services through or from the Division of Child Support. And as Sarah will cover later, genetic testing may be completed as part of the court process to establish parentage. Sometimes there is a question of biological paternity, but legal parentage has already been established. In those situations, parties may go to the lab or go to a lab on their own. We use LabCorp, but there are other labs across the state that do genetic testing. Google for the closest one to your area is often what we recommend. Less expensive option could be purchasing an over-the-counter paternity test. Those over-the-counter paternity tests that can be found in most drugstores, such as CVS or Walgreens. I've also seen them in grocery stores, usually in the family planning sections near the condoms and pregnancy tests. But those over-the-counter tests follow the same science as a lab, but the results do not hold up in court because there's no way to guarantee who provided the samples. As I've been speaking, there's a lot of questions popping up in the chat, so let's see if we can answer.
Yeah, can we do some of these live though? This is
yes,
really
for sure.
This is really the area that people have a lot of questions and concerns about. So starting with Jeanette and the question of what happens if the child was on the birth certificate, but then the testing showed that he is not the father. What happens then?
So we don't go through the voluntary paternity testing. That's one of the reasons that we don't test when there's already a legally established parent. So if they've completed the acknowledgement of parentage at the hospital,
okay.
right?
Yeah.
But that does happen. It does happen, just not through our program. And so if they do DNA testing and they find out that he's not the biological father, they can complete a rescission if they're doing that within the first 60 days after they've completed that acknowledgement. And I actually am aware that happens sometimes. And I don't have the statistics on it, but it does happen. Or they go back through court to challenge that acknowledgement. And that would be a factual mistake, a reason to challenge that they're actually not the biological father that they thought they were when they signed that acknowledgement.
Okay. And then there's a question about the 2-year-old age cutoff. Do you know what the rationale is?
Over the age of 2, a guardian ad litem would need to be assigned to the child, and that's not cost effective for our program. It's cost prohibitive. So we just don't have the funding for that.
Got it. So Gregory, to your question then, I don't know that you can reach out to the GLs or the new Washington Child Advocates Association, whatever the new one is called. I don't know how that works.
This is Sarah. If
So
the
a
child,
father,
oh, go ahead.
oh,
No,
go
you go
ahead,
ahead.
Sarah. Go ahead, Sarah. I was going to refer him to you, so go ahead. Go ahead.
I was going to say, if the child's over 2, that is where you could utilize the prosecutor's office to go through the court process to establish parentage.
Yeah, so much more complicated. For sure. So I'm sure, Jill, that you guys have numbers around this program, and not that we expect that you would produce them now, but does that all get reported from DCS for
It
the volunteers?
it does. Gets reported to our the Federal Office of Child Support Enforcement. They allow us funding to use our funding to run this program. So, and if anyone is interested in specific numbers, just reach out. Our contact information will be at the end of our presentation, and reach out to us directly.
So Michael, that may make more sense for you. I'm not sure what you're getting at in your question, but it may be a follow-up.
And our numbers are constantly changing, so I'll give you the most accurate, up-to-date information.
And then this question always comes up, but how long does it take to get the birth certificate changed at the Department of Health?
And that varies as well. The Department of Health has a backlog for publicly submitted acknowledgements. That's, I think, about 5 months right now. If you complete them at the hospital acknowledgements are prioritized. So those are, I think, about a 1-month backlog, and the Division of Child Support submitted acknowledgements are also prioritized. So really sending them through the Division of Child Support can be a faster way to get that acknowledgement filed.
Any other questions about this? I was surprised that you said there isn't access for currently incarcerated parents. I thought there was.
There is, but not through our voluntary paternity testing program. That program is very specific for a very specific population.
Okay.
Through the prosecuting attorney's office, they can arrange testing for folks who are incarcerated.
And then what's the difference with tribally enrolled parents?
I'm sorry.
So the question specifically, I'm guessing Washington tribes with child support programs have agreements to do their paternity results separate. I mean, that goes through the tribe, not through you
Apologies,
guys.
I guess I meant is there agreements in tribal child support programs with the state? My apologies for the lack of clarity
Oh,
to
there we
get
go. Thank you.
paternity results. Thanks.
Thanks.
So the voluntary paternity testing program and any paternity testing is only determining the biological parentage. It's not determining legal parentage. So if you're using the testing results to then decide to complete that acknowledgement of parentage, then that would be filed with the Department of Health. Or if the tribe is using those results to enter a court order, or one of the county courts is entering those results to enter a court order, that's where those results would be used. Okay. Thanks, Betsy.
So there's one last one, and Jeanette, I think you asked this in a different form up above, but we are just talking about paternity establishment. But your question is, does somehow an order get established based on paternity? And that is not the case, but that's not exactly your question. It sounds like you have experience with dads that have gotten a child support order put in place when they have determined they are not the father. Not quite sure what you're asking,
Yeah,
Jeanette.
yes, I'm here. Thank you for letting me say this. But I was just wondering, how do you guys deal with a father that has been charged child support but finds out he's not the father?
So I think we're talking about legal parentage versus biological parentage. So he maybe is legally determined to be the parent because he completed an acknowledgement of parentage or was married to the mother at the time of birth, or there was maybe a default court order that got entered where paternity testing wasn't done, and then maybe he does paternity testing and that determines he's not the biological father. Well, he's still the legal father. And so maybe Sarah can address this when she speaks, but the result, the fact that he's not the biological father, or that he is not the biological father, he still needs to determine or get it figured out in court that he's not the legal father.
Yes, that's correct. And then the court would deal with what child support has been paid or hasn't been paid and how they want to move forward with that.
Interesting. Thank you.
Thank you.
Okay. Sarah.
I'm sorry, did you call me?
I think this is you, right? Court
No,
order, Sarah.
well, I'll address court order. There's one other one, legal.
Oh,
Okay. So I'll go to how do cases get to the prosecutor's office. So cases come to us a few different ways, and I was doing the slides, and as you all saw, I did not do a great job with the slides. So I was also trying to read the chat, and so I'm going to try and address some of the questions from the chat in my presentation. So I hope I get to that as well. So the question of how do cases get to the prosecutor's office? We can get them a couple of different ways. One way we get cases is off TANF referrals. So if the child is receiving TANF, and that could be with a grandparent, the mother, anybody, if the child's receiving TANF and there are not two parents named, then the case will get referred to our office. And when it's referred to our office, it will go first to our paralegals who do intake, and they will look and see, are their parents named on the birth certificate? Are there not? What information do we have? And send out questionnaires to figure out who are potentially the biological and the legal parents. So that's one way we can get them as TANF referrals. The other way we get them are non-assistant requests for services. These are referrals we can get from any parent. So a father can ask for our services, a mother or an alleged father, because if you were the legal father, you probably wouldn't need our services in this way. But any parent that has custody of the child can ask DCS for this service. There's no income limitations on who can ask for it. There's no fee for the service, no matter who asks for it. And I'll just put a quick little plug in at the bottom. Today we're talking about parentage, but we also do child support reviews. So if you believe your child support should be modified, we do that as well. And we also do enforcement of child support orders. One thing that was asked was about incarcerated persons. So we do handle cases for people that are incarcerated, whether the alleged father may be incarcerated and believes he's a parent, we will accept those cases and work them to the best of our abilities. If a mother believes an incarcerated person is the father of the child, we will take those cases and we'll do genetic testing in the prison or in the jail, and we will do testing of the child outside, and it's not hard to do. So that is one way for an incarcerated person who believes that they are the alleged father of a child to ask for our services. And again, it's free. We will handle all the filing fees. We handle all of the paperwork. We handle the filing of the paperwork for you. We don't represent either party on these cases. So either party can hire their own attorney if they wish to, but we do represent the state and we handle all of the kind of logistics for you. We handle all of the filing of the petition, the summons, the service, the scheduling the genetic tests, the paying for it. All of those parts we handle no matter who asks for it. So although we don't represent you, it's a great service in terms of getting you into the courtroom and giving you an opportunity to be heard by the court in terms of what you would like the court to do and why. Another way we get cases are dependency cases. These used to be automatically referred to our office, but for different reasons, they're no longer automatically referred to us. But if you have a child or a father has a child that has entered the dependency process, you can ask for our services as well. And these are important because, like was mentioned about the benefits of a legal parentage finding, is it opens the door for where the child can be placed. It opens the door for whether you can get parenting plan, whether you can have access to medical records. So although these cases don't come to us automatically, we will take them and we will still handle the case in the same manner we would any other case in terms of reaching out to the parties and getting genetic testing established. So, oops. What do we need to file a parentage petition? The first thing we need is a sworn statement that states there's a reasonable possibility that the alleged biological parent is a biological parent. That's what gives us our basis for genetic testing. So we can have a father come in and say, there's a reasonable possibility I'm the father of this child. We can have a mother say, there's a reasonable possibility this man is the parent of the child. So either parent can make that sworn statement for us. Service. So parentage has a fairly high bar in terms of what we need to move forward. So we can do personal service. And this is one area sometimes our cases stall out for some time because we can't do service by publication. We can't do just service by mail. We have to get personal service. And I think that's important. I think it's important because we want people to have actual notice. We don't want to make parentage determinations based on something that got mailed to your address. We want to make sure somebody got the paperwork and that you have a chance to respond and you have a chance to be heard in court. So, oh, I'm sorry. I just realized my camera was still off. So they set a high bar for service, and I'm glad they do because I think people should know when these types of things are coming. But if we can't get good addresses, if we have somebody who is not in stable housing, it can be awfully difficult to personally serve somebody. So we do our absolute best in this way. We use process servers. Sometimes we have the sheriff do it. We reach out to people, but this is an area where sometimes we're not able to proceed because we simply can't get good service. So once we have filed the petition, the next thing we go to is genetic testing. And for all the reasons that were just discussed, we prefer to resolve our cases by genetic testing. We can resolve by default, which I'll go over later, but our preference is always to have a genetic test. It gives us closure, it completes a case, like you heard. It gives people assurances that, yes, I am the biological parent, now I'm the legal parent, now we can move forward in terms of our family. Somebody asked, what if a mother refuses to do genetic testing? So whether we have mothers sometimes that refuse and we have alleged fathers that sometimes refuse, each case is taken on a case-by-case basis. So the first step is we send people their first appointment. And if they go, great. If they don't, we start reaching out. Hey, we're scheduling this appointment. Is there a better time we can do it, better day, so forth? And we'll try to schedule around them. If they don't do that, then we will ask for a court order that says you've now been court ordered to go do a genetic test. That often gets people to go do their genetic test. If they still don't go, we have the option to seek some sanctions such as warrants. I will tell you, we are careful about issuing warrants and we're thoughtful about issuing warrants. And we're the same level of thoughtful and careful in terms of mothers and fathers. So we have some cases, we have issued warrants for mothers that haven't participated. We've had cases where we issued warrants for fathers and some cases where we haven't. So there are options if the mother won't participate. Our hope is if a mother won't participate, she can appear and she can tell the court why she doesn't want to do it, and she can be heard on that issue, and the judge can decide, yes, you should do the genetic test, or no, you should not. Again, as to why do we do it, it's always necessary if there's multiple parents. We do have cases where there are multiple possible fathers, and in those cases, we have to have a genetic test. We also have to have one if there's a presumed parent by marriage, we have to have a genetic test. So, and I think for all the reasons stated, we always want one to give people that finality. There was a question in the chat about deceased fathers, I believe, and what we do. So we cannot file a parentage case with a deceased father. But our office does, as a courtesy, do genetic testing on deceased father cases. So if a father has passed away, we will, if the mother is willing to voluntarily participate, and family members of the father are willing to participate, we can do testing with the child and say the grandmother or say a sibling to see, yes, these two are related. Now, that is not good enough for a legal finding of parentage. It has been, our experience, good enough for things like Social Security, that genetic test. And sometimes it's just good enough for closure with the family to know, yes, this was the biological child of the person that passed away. We have also done cases where the mother has passed away, because if the father isn't named and that person needs to now go forward in terms of registering the child in school, housing, things of that sort, we have done parentage cases where there's a deceased mother as well, so that the father can then move forward and do the services or apply for services that he may need. So I hope that answers a question about the deceased father, but that is voluntary.
And Sarah, there's just a comment that also helps establish tribal enrollment.
Oh, yeah, very true. That's another great reason. What are the genetic tests? So what we need is the genetic tests and a chain of custody. This is why, when it was mentioned before, tests at Bartels are fairly accurate, but they don't come with the chain of custody. And the chain of custody is what tells us this person and this person took a test and here are the results. The test at Bartels doesn't give us that paperwork that looks at the two people's identification, they've signed, and they've been verified as to who took the test. So what we need to go to court is we need the test and we need that chain of custody. And that often will frustrate people. It's like, well, we took a test. We know we're the father. I get it. I'm not doubting what you say, but we don't have a chain of custody. So we will do a free test. Well, we will pay for the test so that we can have that legal chain of custody. So that is what we need in order to move forward. When do we do them? Unlike DCS, we cannot do walk-in tests. So if you just want to test, then the voluntary test program may be a good place. But if you don't qualify for that, or you want a court order, then we do have to file a case. We have to have your case in our office to do genetic tests. We will then, is there a fee when parents go to the prosecutor's office? No. There's no fee to do this at the prosecutor's office. We don't charge a fee for the filing. We don't charge a fee for the genetic tests. And there's no income requirements as to whether or not you are free or not. So we schedule the appointment for you because it has to be done on our account. And we are very flexible. We will schedule it by where you work. We will schedule it by your house. If you want it done by your mom's house, you want it done wherever, we will schedule it. We schedule it with LabCorp, so we don't have complete control. We have some people that want like Sunday appointments. They're just not open. We can't do that. But we absolutely will work around your schedule in order to get the appointment. If you're like, I need Monday mornings, we will ask for the next appointment on Monday mornings for you. So we understand people have a lot going on in their lives. And we understand that this case is not the only thing most people are trying to navigate. So we often have to schedule multiple appointments for people because life happens, and we will do that. We will schedule it somewhere different if that's better for you. We do some in-office testing, but primarily it's done at LabCorp, which is nice because it can be done by your house, by your job, wherever you need it. So I kind of already did this one, but they're done at LabCorp, and this just goes over again the fact that we will do our best to make it as convenient as we can for you. So once we have genetic testing done, we are then looking at a resolution. So if the genetic test comes back and that person is not a biological father, then generally we move forward to a dismissal. What's nice about it, and I often explain to people, I get a number of parties that are like, I'm not the father. I know I'm not the father. They were with other people at the time. There's no way I'm the father. And I'm like, I get that. But the best thing you can have is a piece of paper that legally says you are not the father. So doing the genetic test solves that issue and takes away the whole argument. So a dismissal order is sometimes a nice thing to have because it says, I took a test, I'm not the father. A default. We do not like to resolve by default, but we will. If somebody has been legally served and they do not respond and they do not do their genetic test, then we can name them the legal father. So it's not our preferred method, but it is an option and we do use it. Trial, I'll go over that in a moment. Trial is generally not for the issue of who is the father. That's generally for issues of parenting plan and child support. So the most common way we resolve cases is by summary judgment. And what summary judgment says is essentially this person has been found to be the biological parent, so there's no question about that anymore, and we can resolve that issue. Before we go to summary judgment, we mail parties their genetic test results and we ask for additional information. Do you want to ask for a parenting plan? What income information do you have? Are you working? Can you provide pay stubs? Because one of the things we will address is child support. So once we've mailed out those results and we get them back and we prepare our motion, we want to name the legal parents. So there's a question about the Department of Health and how people get put onto the birth certificate. Through our action, once the court orders you as a legal parent, we send that to the Department of Health. The certified copy gets sent to the Department of Health and they will update the birth record. We address child support. There are some cases where we don't, and we reserve that for the administrative process, primarily cases with dependencies, because there's so many other things going on that we often allow those to be resolved later through the administrative process. But we do allow people to be heard on income calculations. So you'll have a full hearing where you can say, this is what I earn, this is the information I have these other children, and the court can order an appropriate amount of support. The court will address back support. So once somebody is found to be the father, the court can address support going back 60 months. So the court will look at that. They don't always, but it can be addressed and either party can ask for it. Other issues that come up are things like changing the child's name. That's something you can ask for in this action. Parenting plans are things that can be asked for in this action. We don't take a position on it. We don't say the child should be with this person on Tuesday evenings, but the door is open for you to do that. So often people think if I do this, the only thing that matters is money. The only thing they're going after is child support. And that is a piece of the pie. I'm not going to lie to you and act like child support's not on the table, because it is. But all the other things that were discussed earlier in the presentation about the rights and benefits that come with establishing parentage, I hope are things that get weighed when people are considering, should I establish legal parentage for a child, such as that access to medical records, access to school records, the right to have a parenting plan, the right to get Social Security and other benefits. So although child support is a piece of it, there are so many other rights and benefits that come with establishing parentage that are important as the child grows. So that is the court process to establishing parentage. So at this point, I don't see any other questions in the chat that have to do with the court process. I think I touched on the ones that I saw in there that touched on the court process. So I will open it up now for any questions about any part of the presentation that anyone has from what they heard that we can be helpful with.
And before we go there,
Oh, no,
Marilyn, do you want
I won't
to
go there.
pop the, no, I think we're ready, but Marilyn, do you want to pop the feedback evaluation link in the chat? We ask people to provide feedback so that we know how are we doing in meeting your needs. And also there are questions in there around what else would you like us to bring forward? So I just wanted to get that going. So questions or thoughts that people have? Wonderful as always. It's a complicated arena, and I think doing this annual refresher is a good idea. So I appreciate your willingness to step into this conversation annually so that people can get their questions answered or re-ground themselves in the topic. There was a comment made in the chat about the voluntary testing program does have the chain of command, so it does hold up in court. I just wanted to say that out loud. And Jill is also remarking that that is also set up in such a way that it is really built around people's busy, crazy lives, because we know that can become a barrier.
And if you do the voluntary testing program and you are interested in a legal finding of parentage, because say you want to do a parenting plan, you want child support addressed to the courts, we have had people come to us with the results and the chain of custody, and we can take your case here and move forward with the court process. So sometimes we can work together in that way. If once you have the results, you're like, oh, you know what? I actually would like to know. You know what I mean? More information, or I would like to have a parenting plan put in place. You can. How do you get parentage if the father is out of state? Will it be transferred to that state? So that is a jurisdictional question. So the best thing to do in that case is to ask for the Division of Child Support to open a case, and they will determine where was the child conceived, where has a child lived, where do the parents live, and then figure out should the case stay here and we try to test there, or will the test be referred to the other state and then they will handle it on their end. What are some of the exceptions that would allow a mother to be allowed to not participate? So the biggest exception out there is sexual assault. There is a statute in place that if the child was conceived by sexual assault, then the mother does not have to participate and does not have to go. The parentage case can be shut down. I am not aware of any other firm exceptions. It's somewhat of a case-by-case basis for our office. Now, another thing to remember, our office does not hold the right to handle all parentage cases. So if for some reason your case doesn't qualify for us to handle it, or you don't feel that we are handling it in the way you would like, you always have the right to file your own parentage case. And you'll always have the right to be heard in our parentage case. So if there's a case where, as I said, the mother won't participate, and we set a hearing for her to participate, and she comes and says, I'm not doing it for this reason, the alleged father has a right to be heard at that same hearing as to why testing should be done.
So I have a question. So because we have a lot of scenarios where the mother is just absolutely defiant, and she feels like there's nothing you can do, and pushing it in the father's face. How realistic is it that they go and pursue this mother? Because I know you said default. Can a father win by default if the mother doesn't show to the hearing or doesn't answer the summons that you say, hey, we need to get this cleared up?
So our office will not default in that way. The reason we won't default is because we have no way to establish that there's no other potential fathers. Now, whether a private party could default in that way, I don't know. I don't know the answer to that, but our office can't default in those cases because in order for us to default on a father, we have to have a statement under penalty of perjury that there are no other possible fathers. And since the father isn't able to make that statement, we won't enter a default in that case. But maybe you could in a private case.
Thank you.
Mm-hmm. Does a mother have to? Oh, sorry.
Oh, go ahead. Go ahead.
Does a mother have to have a report? Not necessarily, no, they don't. What will happen is if we have a parentage case and the mother is alleging that the child was conceived by sexual assault, a special hearing will be set in front of a superior court judge, and the judge will hear evidence and argument from both parties. And I'll tell you, this is a fairly new area of the law, so judges are handling it a little differently. But each parent will be able to put forward evidence and information to show, yes, a child was conceived by sexual assault, or no, it wasn't, and the judge will decide. So do you have other fathers who can mentor? Oh,
Yeah, I was
okay,
gonna
so that's
just
another
pop
separate
in on
question
this
for
one.
me. Okay.
Yeah, I was just gonna pop in on this one, Carrie. You're asking about fathers that can be support to one another, and this is one of the greatest learnings over the years from the Fatherhood Council perspective is the social isolation that many men experience and the difficulty in finding resources really become barriers. And just having someone to talk to that's been down this road before them or is currently involved is really helpful. There are fatherhood programs around the state, not enough, we believe, and there are big deserts in parts of the state where there aren't folks that are gathering, but it's getting better. And so I'm going to have to ask Marilyn for the answer to this one, but the Washington Fatherhood Council website is going through transition, and on that website we listed our environmental scan results and showed all of those programs. Marilyn, did that get transferred to your website? And if,
Are you talking about the map of resources?
yep,
Yeah, no, that has not been transferred. It's still accessible right now, and I think if people reach out to me, I can find ways to share that. We just don't have the capacity to put all the wealth of information on the new website, unfortunately.
so they will get a contact information for you. So Carrie, that's makes it a little bit more difficult, but there are I'm trying to think, maybe 211, Washington 211. If you call and ask for a fatherhood program, you might find that they have their data now in a more descriptive way rather than just parenting. It may say this is a specialized program that's available for fathers. So that's one way to do it. The other thing that is happening is informal networks of dads. So there's curriculum-based fatherhood programs across the state, but there are also informal networks of dads, and Pierce County has one of the most robust. Tacoma Dads is a really, really large network of dads that are there to come together socially, to come together in mentor relationships. So depending on where you are in the state, you may find more depth in those kinds of programs than others. And I'm also happy if you have a specific area that you're talking about or a specific dad that you're talking about, I'm happy to send you to that resource, and you can get there through the Washington Fatherhood Council at Gmail address, which I'll put here in the chat in a moment. So sorry, some of the resources that we had have gotten a little bit harder to find since we lost our funding, but it's not that the knowledge doesn't still exist. It absolutely does. And Napuna is still wanting to come back to the issue of incarcerated dads. So I haven't had a chance to read this one. If someone has read it, if you could address her question.
Yep. And Bridget gave a great answer about
Oh,
an
it's already
incarcerated
been
father.
answered. Okay.
Yeah.
Okay.
And just one thing I'll add to that, the grandmother or anybody can stop by DCS or stop by the prosecutor's office and get the paperwork to start the case. And if they can get it to him and we can get it back in and filled out, we can start a case while he's still incarcerated. So anyone's free to stop by and get the paperwork that's needed. And if they can get the paperwork back to our office or to DCS, the case will get moving.
They could also call us and we can actually send the application
Good
forms
idea.
to the father
Great idea.
in prison. We just
Yeah.
need to know what is his appropriate mailing address, and we can mail paper application forms to him as well.
Great idea. I didn't even think of that.
Fantastic.
Hey, this is Larry from Dads, and I want to come back to Sarah, and I don't mean to beat a dead horse, but it's a concern for us. I'm alternatives for dad services, and we service dads, right? We have dads that come into our office who want to be a part of their children's life, but we run into a stone wall, right? Because the mother for no other reason, just refuses to participate. And I was hoping to find some other alternative measure or answer to say, hey, if she refuses, right, and we've done all we can, what other alternatives does he have? Because these dads are the dads who've been with this and they know that their father, but if they come to your office and say, well, we did our best, there's nothing else we can do. And I just want to know before I leave off this call, is there any other answer or alternative that we can address the dads that we serve with to give them some semblance of hope?
Um, I mean, I guess that goes back to if they've come through our office and we have done the best we can to establish parentage, and there are roadblocks that we can't get past, I would say the next option there's a you can file a private case. Like I said, we're not the only ones that can file parentage cases. So you do have the option to file a case on your own. You always have the option to hire counsel, which I know is cost prohibitive for a lot of people, but that is an option there for you. I don't know. I think you asked a question earlier about will we default mothers? A private attorney that does private cases may be able to answer that question. If you're able to serve the mother and she does not respond, can you default? Like I said, I don't know the answer to that, but a private attorney certainly would that does family law. So that may be an option for you. I guess those are the best answers
I
I
think
have. Go ahead.
I think the disturbing thing is that,
Hmm.
and I'm speaking as a father, and I've been through the court system. The disturbing
Hmm.
thing is that you will find default on the father, and it's not you personally. I'm just talking
Hmm.
about you find default on the father for not showing up, but the mother again has a loophole. I'm just not coming because I'm angry with him, and that is the majority of the time. I just sent my son through your office,
Hmm.
and he hit that wall. She eventually showed up, but she refused because um, they weren't together. And if you're not going to be together, you just don't have a child. How about that?
Yeah,
Right.
and we definitely run into that. And we have some people that once it comes from the prosecutor's office, they're willing to participate. We have some that once we do a court order, they're willing to participate. We have issued warrants when mothers aren't willing to participate. Those are fact specific, as they are with either party. Um, so we try to use all the resources we have available, but we do not have 100% success rate on either side.
Okay. My one last thing.
Hmm.
So I've been told that if a mother is receiving TANF or something in that nature, right, from
Hmm.
assistance, is that if she refuses to show up in that regard, will that be something that's held against her, or the
Yep.
TANF will be withheld?
Yep, that is something else we do. If the mother's receiving TANF for the child and she will not participate in our process, we will sanction her TANF so it can be cut, it can be lowered or terminated.
Thank you
Hmm.
so much. Thank you.
Uh-huh. And then um we have two hands up. I don't know which one came up first. Roberta?
Hi, I just got a question. Oh,
Hmm.
I work for NIPSEC, for the tribal child support, and right now we have a new attorney, and he's not wanting to do our what is it, paternity cases because he says that it messes with his jurisdiction over our child support cases. If we can maintain chain of custody and get that documentation to you, would you be able to help us with that, Sarah?
Um, yes, is my hopeful answer. Um, so when we get cases that there is a party that is a tribal member, our first step is to reach out to the tribe and ask, do you want this case? And sometimes they say yes, and if they don't, or if they don't answer, we'll take the case. So if you have cases where you have parties that would like legal parentage established, we would be happy to take those cases.
Yeah, because
We'll take them
this
if you haven't
specific
done
one,
genetic
like we
testing.
already did the DNA on.
Yeah,
And
and if you,
once it got to that point, like we got to a standstill and
Mhm.
ended up doing a affidavit because um, after that, dad was like, okay, I'm dad, I'll sign the affidavit because we got tired of trying to wait for our court process here. So we ended up doing the affidavit, but like moving forward, if we can't get our attorney on board, is that something you might be able to help us with?
Yeah, I would love to connect with you after this and figure
That
out
would be
how we can
great.
get those cases over here. And like I said, we can take them before you've done genetic testing. After we can do the
Okay.
genetic testing on our side, you can do it on your side. But I think
Yeah,
that's something we can
this was
definitely
new
work
for us.
together on. Yeah, I think that's something we can definitely work together on to get those cases finalized.
Oh, perfect.
My email is going to pop up at the end. If you
Okay.
wouldn't mind just shooting me an email and we can connect and figure out how we can get those easier pathway for those cases to come over if you have them.
All right, great. Thank you.
And Janet, I believe, also had her hand up.
Yeah, I'm just going to jump in with a question I had earlier about is the establishment. We have a case that the child's been in guardianship for 10 years, pretty much since birth. The father passed when she was 4. He acknowledged parenting or parental ban by just a letter, and that he wanted the guardianship to go to this family. But nothing has been done since. There is a grandparent, a grandfather, who acknowledges his grandchild. And but you mentioned that they cannot say, or they don't really have the ability to say that this is his son's child or not. So I'm kind of like trying to, like, other than going through the court, there is another sibling just to establish a parental connection there. Would that be a way you could go?
So we do the deceased father cases.
Okay.
So if, and you said it's a guardianship, right?
Yes. So
Yeah,
she was
so who,
placed,
go
she
ahead.
was removed from the mom. She was removed from both parents when she was just a baby, put
And
to not foster care, but a guardianship, and has been in that since then. And I believe she gets TANF, has continued to get TANF.
and all of you are in Kitsap County?
Yes.
Okay, so I can speak for King County. I don't know how Kitsap County Prosecutor's Office handles deceased father cases.
Okay.
But if we have the child, and the question I would have is, can the guardian give permission for us to test a child? And I don't know the answer to that. But if we can test a child and there is a grandparent available and willing to do the test, then we could do a deceased father testing between those two, which at least say, yes, this child is related to this person, which may be sufficient.
Okay.
We just can't do an establishment of parentage. We can't file a case. We can't go to court. We can't get a court order. But we may be able to do just the testing. That's how King County would handle it. If you would like, you can also email me with your facts with that question, because it's a very fact specific question. And maybe we can touch base with Kitsap County and see what do they do, how do they handle it, or could we do the testing in King County if they're willing to come here? Because we don't have a jurisdiction issue because we're not filing anything in court. So maybe we could do it here in King County if they're willing to travel down, if Kitsap County doesn't have a procedure in place for deceased father cases. I just don't, and I don't know that off the top of my head.
Right. Okay. All right. Well, thank you. It's just been, it's just starting to be more of a problem with the birth mom. So yeah, I think they're going to need to establish some stuff here.
Yeah, and they may, through the guardianship, be able to get a court order for the genetic testing to be done. That may be another way to do it. But yeah, if you want to shoot me an email, we can look at it.
Okay, great. Thank you.
Any other questions or thoughts? Thank you, Marilyn, for putting the evaluation in the chat. If folks could please take a moment to do that. Many thanks to Sarah and Jill and Bridget for this wonderful presentation. There have been lots of positive comments in the chat, and we appreciate your written feedback as well. These provider learning series used to be monthly. Excuse me, froggy. we have lost the ability to have quite that frequent and are really looking for the new cadence. Our hope is that it will be about every other month. So we're working on the next one. Stay tuned, and please do put your comments in the evaluation about the topics that you feel like are important from your touch to this topic. And we will continue to do these as long as we are able. So thanks again to our presenters, and appreciate the follow-up that you do with folks. That makes a huge difference. And I also put the Washington Fatherhood Council email in there, and I can forward those along to people if I get ones that I don't have the answer for that I can share. And then Marilyn, I think you also suggested that you would put your email in the chat. Or I'm not sure how you would like to be contacted, but you said at one point that that might be a resource for people as well. So thanks everybody for joining us. You have a few extra moments in your day.